the mission of the summit and what did you accomplish?
I think the mission of the summit was to show how desperately the international community needs an immediate response to the challenges we are confronted with today. We have to learn from the lessons we have had in Rwanda, in Srebrenica, and of course Srebrenica is very important, and it in this area in particular, because people here on the territory of the former Yugoslavia, to make use of the term of the International Tribunal, they are deeply concerned, and I saw in the faces of participants that they actually were deeply concerned about some of the pictures they had never seen. One thing is to speak about the law, one thing is to try to amend the law, and the other thing is to be confronted with the pictures of these crimes, and also to learn about people having been members of our civilized world, priests, or in the other instance, physicians, doctors, having sworn to protect life. However, they did not. It was not only the mission to protect, they actually killed human beings. And I think what can we do together is the question before us. And I think this conference, this summit really has served as a fundamental added value to come closer to the answers we desperately need.
The responsibility to protect has taken a beating lately. What is the message you are sending to the international community?
The message is that we can't afford to look away any longer, as it was done in particular in Rwanda. I think the mere existence of the International Tribunal for the former Yugoslavia can be attributed to the fact that the international community omitted to act at that time. And from my perspective as a judge, it's very important that we are not only entrusted to adjudicate this fact ex post, but when it's possible, already before or during the commission of these heinous crimes. I'm deeply convinced that had the United Nations established the International Criminal Tribunal for Rwanda, for example, immediately when everybody knew that we are in the eve of a genocide, then it would have been easy to prosecute those publicly inciting genocide, because we all could see it in our civilized world. It was broadcasted and we didn't act, even though it was already a crime, because the public incitement to genocide is a crime as such. And similar in other situations we have today, for example, in Syria, and I think it's a crying shame that until today's date the ICC was not vested with the power to prosecute these crimes, that the situation was not yet referred to the Permanent International Criminal Court.
How can member states support the UN in the R2P mission?
I think the best thing you can do is first to do your own housekeeping, to take care that the necessary measures are taken on a domestic level, in particular that you have a special envoy or contact point taking care of the responsibility to protect as it was highlighted in particular by Dr. Simon in this conference. And had we in all countries such an institution, a lot would have already been done. And then it is for all countries, and not only for the member states of the Rome Statute of the permanent ICC, to take care that everybody is really equal before the law, and there is no impunity also for the future for those coming from other countries, like, and unfortunately I have to put names on this, Russia, China, and the United States.
The UN says its hands are tied because of the lack of political will among key members of the UN Security Council. What is your reaction?
That's absolutely a correct observation, that the veto powers apparently block each other, because you have to be aware in all these conflicts, the first question you have to ask yourself is, what is the interest of an individual country? And in particular, the interest of the veto powers in Security Council. And when they have a particular interest in being active and one of the main players in a concrete area, they tend to omit their own duty. I would call it a duty to protect, and therefore in the future we need a mechanism where it's not for the veto powers to obstruct the work of the independence of the judiciary. I think the independence of the judiciary is key in this area. We have this ideal of Montesquieu in all civilized countries, and I wonder why it is not possible that proactively also the International Criminal Court or a similar organ could immediately intervene. So, from my perspective, it would be for all countries to immediately implement a mechanism allowing for immediate response, both as in terms of military actions, but also in terms of the civilized answer by means of the judiciary.
Please describe your understanding of the R2P, what it means as far as nations' obligations, and what good is R2P without the law to enforce it?
I think if you see, you can't look into a domestic legal systems and simply look, where is the responsibility to protect. When you see it as a whole, then you have, first of all, hopefully, the implementation of, say, the Anti-Genocide Convention, and also to have the crime against humanity in your own legislation. But the duty and the responsibility to protect emanates, at least in certain countries, from the prosecutor's duty. It's mandatory to not only to react, but to open a prosecution. And this also should happen and must happen on a global level, that it becomes mandatory when we are confronted with such a situation. And it was correctly highlighted by numerous speakers of this conference that had this approach been taken in 1994, 800,000 people would be still living amongst us. Well, thank you.